In September 2022, defendant Karis Juno Green was charged with unlawful possession of methamphetamine and unlawful possession of drug paraphernalia by the state of Kansas in the courtroom of Judge Phyllis Webster in the 13th Judicial District Court of Kansas in Greenwood County. On August 24th, Miss Green was chased on a highway by police officers for speeding, which led the police to find drugs in her car. Miss Green had a paid bail on the value of $7,500 and failed to appear on court on her court date. If the defendant fails to appear at any scheduled hearing or violation of court-imposed conditions, it may result in forfeiture of the bail and issuance of a warrant for arrest.
Let's take up Miss Green. And how do you pronounce your first name? Is it Karis? Cirrus?
It's Karis.
Okay. We are on the record in 2022 CR 136, State of Kansas versus Karis. Is it Juno, like Juno Green. Karis Juno Green. Miss Jill Gillette, County Attorney for the state. Miss Green in person and pro se. Okay, does Miss Green still have an outstanding warrant? Where are you, Miss Green?
Yes, she does, Your Honor.
Okay, where are you, Miss Green?
In Alaska.
Do you know you failed to come to court?
Yes, I do.
Why did you fail to come to court?
Well, honestly, I got mixed up on my days, and when I looked at I looked down on my phone and I saw that it was the 13th, and I was like, oh my gosh, it's the 13th, and it was hours has passed because I forgot about the time difference too. And so I called the person I'm supposed to check in with every week, but she didn't answer. I'm assuming because it was probably too late. And yeah.
Okay, so on August 22nd, you posted a $7,500 bond with us. Who's Cynthia Miller?
That's my mom.
Okay, you just cost her $7,500 by not coming to court. She's gonna have to lose that.
There's no way that
And that was a cash bond, it looks like, with the paying party authorizing the money to be paid to the costs of the case. Then you post another bond on September 13th. Let's look at that. No, that's probably the same one. Yeah. Yeah, you were supposed to be here September 13th and you didn't. So same bond, but that's for the forfeiture of it. And then you had a failure to appear warrant. And now we're looking at motion. 5 days ago, there was supposed to be a motion for judgment on bond. Was that heard and granted, Ms. Gillette?
It's scheduled for November 18th at 1. The forfeiture is scheduled for November. That was the date that was given to us.
Do you get the impression that maybe it was a big deal to forget court, Ms. Green? Okay. Well, you haven't had your reading of your rights and charges since you failed to come to court when you were supposed to. So let's go over the charge. You've got a pretty big charge here. It's in count 1. You're accused of unlawful possession of the controlled substance methamphetamine. That is a level 5 drug felony. If you are to be convicted of that, depending on what your criminal history is, you could serve at least 10 months, up to 42 months in the Kansas Department of Corrections, which we commonly call prison. Okay, up to 42 months in prison. Is your hair more important than your prison sentence? Okay, because you seem like you're distracted with your hair, and I would expect you to be attuned to this prison sentence that you're looking at of 10 to 42 months. You're also looking at a potential fine up to $100,000 if convicted. In count In count 2, you're accused of unlawfully possessing drug paraphernalia in the form of a glass vial, hollow pens, syringes, rolling papers, and a glass smoking pipe, possessed with the intent to either contain, conceal, inject, ingest, inhale, or otherwise introduce a controlled substance into the human body. This is a Class B non-person misdemeanor, which means after you get through with your prison sentence, you could be ordered to come back to the Greenwood County Jail and serve another 6 months and pay another fine up to $1,000. So do you have any questions about what they're saying you did and what the possible penalties are that I've gone over with you?
Under Chapter 21 of the Kansas statutes, a drug severity level 5 felony is punishable by 10 to 42 months of prison time and a $100,000 fine. The harshest penalties are applied for the unlawful possession of opiates, opium, narcotics, methamphetamine, or amphetamine. A Class A misdemeanors means up to 1 year's jail time and a $2,500 fine. Class B misdemeanors, up to 6 months jail time and a $1,000 fine. Class C misdemeanors carry a maximum sentence of 1 month's jail time and a $500 fine. And then there's the unclassified misdemeanors, carry the sentence specified in statute. Or, if no sentence is specified, the penalty defaults to a Class C misdemeanor. In Miss Green's case, she was accused in a misdemeanor Class B and a level 5 drug felony.
Now, we have to decide what to do about that warrant. I can make you turn yourself in there in Alaska, but I don't want to have to make the sheriff pay to go get you. Maybe they want to go there. It's a lovely place, I'm sure, this time of year. But Ms. Gillette, what's your thought on that? On the warrant?
If the warrant's lifted, I would like her to call court services each week so that we know where she is.
Do you have a position on whether it's lifted or not?
If it's, I'm fine being lifted if she calls court services every week.
Under Sheriff Cox, does your office take a position on what to do about that warrant?
Yes, Your Honor, I do.
Okay.
I am fine with you and Miss Gillette lifting that warrant, but I would like to see a $50,000 OR bond where she turns herself into local law enforcement, and that way we know exactly where she is, because I have information that she's actually in Pueblo, Colorado, not Alaska.
Pueblo?
Yes.
No.
Who was the gentleman walking around behind you in the picture a while ago?
Oh, that's my friend.
Well, who is he?
His name's Dale.
Dale what?
Dale Whitman.
Dale Whitman? How do you spell that?
One second.
Well, just have him come on up here.
Good afternoon, Your Honor.
Good afternoon. Can you put your face in this camera, please?
Oh, I'm sorry. I didn't realize that was on the video. I apologize for my appearance.
Okay. All right. Your name is Dale Whitman, is that right?
That is incorrect. It's A.M.
A.M. And how are you connected or related to this young lady?
I'm a friend, and I specifically met her friend, Erin, who was involved in the same case.
Okay. And where do you live?
I live in Green Mountain Falls, Colorado.
And you're at home right now?
I am.
What's your address?
My address Green Mountain Falls, Colorado, 80819.
All right, thank you, sir.
Even though Miss Green wasn't under oath, judges expected defendants to be honest. Under Chapter 21, Article 59, Section 3 of the Kansas statutes, it is stated basically that a perjury is an intentional and false statement to get any kind of advantage or to avoid any punishments by prior actions. Miss Green damaged her credibility by lying. This way, Judge Webster may rule against Mrs. Green's case, or a previous decision could be reversed if based on false information.
Why'd you lie to me? You realize you put me in a position where I can't trust anything you tell me now. So tell me why you lied. What was the point of that?
I just don't, because I forgot to tell the person I call into weekly that I decided to go back to Colorado before my court date. But I was thinking about, or my mom was going to get me a plane ticket back to Alaska.
Your mom doesn't happen to be there, does she?
Huh?
Does your mom happen to be in the house with you there?
Oh, no. But I can give you her information and stuff.
No, I've got some information on that bond that you're costing her. Well, I was ready to set aside your warrant, but then you lied and said you were in Alaska, and I find out you're in Colorado. And Undersheriff, did you say you had information that she'd been in New Mexico?
No, I said Colorado, Your Honor.
Okay.
Initially, it was Pueblo.
Oh, okay. Pueblo is what I was thinking of, and that's not New Mexico. All right. Does that change anybody's recommendations since she flat lied?
I think the warrant should stand, Your Honor.
Yeah, that's what I'm thinking too. We're going to leave that warrant out for you. I'll leave your court date. You can still call back and find out who your attorney is, but if you're smart, you'll go down to your local sheriff and turn yourself in on your warrant.
Please, is there any way that you can just lift the warrant?
Well, I would have if you hadn't lied to me.
I'm so sorry.
But like I said, I can't believe anything you tell me now. I mean, you just sat there and looked at the camera and just flat lied.
I'm sorry. I'm just really been stressed out. My uncle, who was like my best friend, just passed away while I was in jail. That's why we were going out to Georgia, is because he passed away.
Where were you going?
To Savannah, Georgia.
Weren't you going the wrong direction from Kansas?
I don't believe so.
You were going to Savannah, Georgia, because your uncle just passed. You were in Kansas, and you ended up in Colorado. Is that right?
No, before I got arrested, I was going to Savannah, Georgia. I was just following the maps, like where the maps told me to go.
But you ended up in Colorado. Those are
No,
opposite directions.
before I went back to Colorado, before I got out of jail. Before I even got arrested, I was heading to Savannah, Georgia, because my uncle was on his deathbed. It was really, we were pretty close. And it was my mom's last living family member, because my grandma and my aunt had passed away like a couple months before that. And so, it's been really hard.
And your mom's in what state right now?
She's in Palmer, Alaska.
And she came all the way to Kansas in September to post your cash bond? Is that right?
She was in Savannah, Georgia, when I called her, praying, like seeing her brother in the hospital. dealing with that, and then she came to Kansas to bail me out.
So she was in Savannah, Georgia, dealing with her brother on death's door, passing away. And then she had to drop everything there and come to Kansas and put up $7,500 cash to get you out of jail. And then you failed to come to court for the day you made bond. And now you have lied today and told me you were in Alaska when in fact you are in Colorado. Is that correct?
Yeah.
Whose voice was that I just heard?
That is Marshall
Who's Marshall?
Goings.
Law enforcement is on.
All right. Are you there for her on her warrant, Marshall? All
I
right.
am.
But
And again, why didn't you tell me you had a marshal there to take you into custody?
I was getting to that. I was.
All right. Okay, well, you're going with him now then. We're gonna quit playing games and
I wasn't trying to play games with you, miss. And I really apologize for lying to you in your court. It wasn't right. I'm just
Go with the
trying to do the
officer. You've
right
taken
thing.
enough, I'm sorry, I'm cutting you off there. You've taken enough time of the officer. How long's he been there?
Just took like 5 minutes.
All right, well, you go with him. You go with him. All right, thank you.
What's my bail at?
Well, he can tell you when he gets you down there and looks at your warrant. You better call your mom and tell her you cost her $7,500 on her bond. And we'll be in recess at this time. Thank you, officer.
Thank you.
You're welcome.
I'm so sorry, but. All right.
Sheriff Cox did warn the law enforcement to get an officer in the address that Miss Green would be taken into custody. In Miss Green's sentence hearing, Judge Jan Satterfield was the judge on the sentence. Miss Green was sentenced with presumptive probation for 15 months. On July 26, 2024, Miss Green was arrested for probation violations. Her bond was set at $2,500, and she bonded out. The next case we will review occurred on October 11, 2024. Defendant Daniel McGough has been charged for committing assault, resisting, or obstructing a law enforcement officer in violation of Section 750.81d of the Michigan Compiled Laws, a felony offense. Mr. McGough was arraigned on the same day, decided to waive his Sixth Amendment to have a professional or court-appointed legal counsel represent him in court, representing himself. Mr. McGough was released on a $5,000 personal recognizance bond. The court set a probable cause conference for October 24th. Before the scheduled conference, on October 20th, 2024, Mr. McGough submitted a document titled Motion for Discovery, Subpoenas, Suppression, and Other Relief Related to Incident of October 11, 2024, to the prosecutor's office, which then forwarded the motion to the district court on his behalf. Mr. McGough failed to appear for his court date, leading to the rescheduling of the probable cause conference to November 14, 2024, before Judge Cedric Simpson in the 14A 1 District Court of Washtenaw County, Michigan.
You're going to represent yourself?
Yes, Your Honor.
Okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened.
Pardon?
The incident on October 11th, the reason why I'm here, I would just like to announce a brief summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not, but I don't think I properly served it on the prosecutor. So I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a
Okay.
discovery. I don't know exactly what the procedures here is. You know that wrongfully.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
Okay, you haven't started out well.
sorry. I'm here because I'm told to be here today, Your Honor. That's the only.
I know.
So what I want to
Kind
do,
of goes out in my name. So yes, I know why you're here. Let me ask you this. You want to represent yourself in
yes,
this?
yes, Your Honor.
You don't want help?
No,
Okay. So I'm going to do this. I'm going to apprise you if you wish to represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to. And the court will not play favorites. The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
That process is throughout the whole discovery and trial.
Pardon?
I can be assisted with if I can.
If you
later
request
charge.
an attorney represent you in this matter, that the court will at that point, if you cannot afford to hire one, the court will make sure that you have one. If you wish to get get your own attorney, the court will afford you that opportunity to do that. You understand that?
I do.
So what do we wish to do today?
I would like to first file a request for suppression of this evidence until full
Suppression of what evidence?
of body cams, squad footage,
On what basis would you be doing that?
Miranda versus Arizona,
Which says what?
that I was not read my rights prior to being detained. And because of that, any violations that I could have possibly said that could impede my case.
That's your basis for the suppression of body cam?
That I have the right to be read my Miranda rights and know that anything that I say can be used against me. I was not notified.
So that's your basis
to suppress
the body cam.
I'm not trying to suppress it from the court to see. I don't want it in the public domain. I don't want it. Anything that happened, I was on the scene. The police were on the scene for 2 minutes. They were dispatched there over a fight.
Contrary to popular belief, an arrest is not rendered invalid merely because officers failed to read the so-called Miranda rights at the moment of arrest. In the 1966 decision Miranda versus Arizona, the Supreme Court set forth a more specific requirement. Before engaging in what is known as a custodial interrogation, questioning a suspect who is in police custody, officers must advise the individual of their right to remain silent and their right to legal counsel. If these warnings are not provided, the arrest itself is still lawful. However, any statements made by the defendant during an un-Mirandized custodial interrogation may be excluded from evidence, meaning they cannot be introduced in subsequent court proceedings. Mr. McGow thought his rights were violated, which would make the police officer's body cam inadmissible in court. Mr. McGow files a motion to suppress the body camera footage from his arrest, arguing that he was not informed of his Miranda rights before being detained. However, Judge Simpson denies the motion. A motion to suppress asks the court to exclude specific evidence from use at trial on the grounds that it was obtained in violation of the defendant's constitutional protections. Even if Mr. McGow experienced custodial interrogation without being said his rights at some point during his arrest, that omission would not justify excluding the body camera footage. The Miranda rights applies solely to compelled testimonial evidence, not to physical evidence. Consequently, while any unwarned custodial statements by Mr. McGough could be redacted or excluded from the footage, it is highly improbable that the video itself would be suppressed due to a Miranda violation.
You're going to have to put more in writing for me to even understand that, because as it stands here right now, based upon what you told me, I'm going to deny your motion.
Deny my motion to suppress under Miranda?
As you're calling it, your motion's denied.
Okay. Maybe I'll formulate my request a little more precise to my specific conditions, but I also am requesting that there's full discovery in this process.
Okay. Have you sent a request to the prosecutor's office for discovery?
I have not. Nope.
Have you asked them, how do I get discovery?
No, I will be doing that.
Do you ask anybody how to get discovery?
I asked a couple of the clerks, but they can't, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay. Well, I'm going to, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Okay.
Next thing you want to do.
Discontinue all hearings until there's substantial evidence on file.
Okay, that doesn't happen that way. I don't know what discontinue all hearings mean.
I don't know either, Your Honor. I'm just representing myself over here.
This is going to be a long process if you just are throwing stuff out there.
I tried to prepare my best for this. I'm really
okay. This was your best. Then you may want to consider getting an attorney, but I'm going to let you go because you have a constitutional right to do it. But this is going to be a long, arduous process if we're going to go at this rate.
What does the prosecution expect next in this case?
Pardon? What do you mean?
You're asking me for what I want out of this case and what I expect.
I'm asking you, what do you want to do today?
I want to go home and have all charges lifted.
That's not going to happen.
Okay, so
I mean,
what do I got to do?
Going home is an option, but the charges aren't going anywhere.
I understand, and that's the end goal of where I want to be one day, acquitted of all charges.
Yeah, I don't mean to interrupt, but I am from the public defender's office. I'd be happy if the court wanted to pass us to talk with this gentleman.
He says he wants to represent himself, and if he wants to talk to you, then yeah, I mean, I know, Mr. Getty, and I appreciate it, but what do you want to do, sir?
I'm not sure what you're asking me. What are my options, sir, Your Honor?
I'm going to take a break because I have to have something happen before noon. I will call the Spanish case up afterwards. I will also then call the one plea, maybe, that we have, and then I'll recall your case in the next block.
Okay.
And then maybe between the time I leave this bench and come back, you'll figure out exactly what you want to do.
Yeah, I'll
maybe how to do it.
I'll do that.
Or maybe if you want an attorney to represent you to help you through this process, because otherwise this thing could much go south for you.
Yeah, I understand.
Not be good, but I'll let you think about that. That's your call.
All right.
Court's in recess.
Mr. McGough requested for discontinue all charges, which doesn't work that way. To dismiss a case or a probable cause, the judge needs substantial evidence to accept a request of the defendant, or at least a very logical argument that the court could use to identify gaps on the prosecution side. When Mr. McGough waived his Sixth Amendment to have a counsel represent him in court, Judge Simpson reminded the defendant that the court could not help him or assist in any legal way. Canon 3 of the Michigan Code of Judicial Conduct requires judges to carry out their responsibilities with impartiality and to refrain from any behavior that might suggest bias. The canon also recognizes that judges may make reasonable efforts to assist self-represented litigants in understanding court procedures and ensuring they have a fair chance to present their case. However, it cautions that such efforts must not grant these litigants an unfair advantage or undermine the judge's neutrality. As a result of this restriction, judges might clarify procedural matters, but are prohibited from offering substantive legal advice.
Your Honor, when the court passed this case and left the bench, the defendant did hand me a copy of his motion. I took the recess of the court to file a response. I hand-delivered it to the defendant, as well as handing the copy to the court. If I may just respond to the record.
Yes.
Thank you. So this motion was sort of put in 3 different sections, for lack of a better term, and they seem to all, like 1 through 11 in each section seems to be the same item. So I only responded to the middle section, which were the motions and requests. The first motion was to compel the testimony of officers at a deposition. I'm asking the court to deny that. As the court is well aware, depositions are not appropriate in criminal court. Does the court want me to go through each one and then make a ruling on all, or do you want to do one at a time?
Let's do one at a time.
Okay.
All right. You got any response to the people's response?
Not for that, Your Honor.
No, motion denied.
Thank you. The second request is request for discovery, where the defendant appears to be requesting that we produce different discovery items, as well as there's a sentence here that says the defendant possesses exculpatory video footage. Request an opportunity to submit it for review. If he wants to give us something, that's fine, but I just think he should go through the normal discovery process, and I'm not saying the court not order what he's requesting in number 2, because it doesn't appear that there's been any request filed for discovery that hasn't been fulfilled or completed at all.
Well, here's what I'm going to do, at least at this point, is I'm going to deny the motion, that portion of the motion also. When he submits his request for discovery, then I'm going to deny that one specifically without prejudice. That way he can raise whatever issue he may have.
I agree completely. Thank you so much. Number 3 was particularly troubling to the people, as it appears to be a request for the people to get medical records for some person and give those to defendant. I responded that request was unclear, but it appears to be that the people execute a search warrant to obtain medical information for an alleged witness who does not appear to be mentioned in the police report currently in possession of the people. Unless otherwise directed by the court, the people would think that people do not intend to execute a search warrant to seek out private and potentially privileged medical information for this person.
Your Honor, in response to that, I have a FOIA records describing the witness and his shirt that he was wearing, which is the reason why the deputies or the detectives were dispatched to the Puffer Reds parking lot at 3 a.m. that morning. I also have a picture of the witness being right there when I got arrested. I mean, I can show you it. It's quickly available here for me to show you, but I mean, he's really within. I
really would be objecting to the defendant showing anything to the court that he has not disclosed to the people.
So given that I do have FOIA on my CAD records for the dispatch record of police when they made comments saying there's a Huron Valley ambulance dispatched for a person due to high intoxicants. I wasn't dispatched through Huron Valley, but this is in my police report. I think this is valid enough to say that he is a part of the same scenery and event.
Do you have a name?
His name is Jacob Spalding. I've known him for 15 years. I was with him throughout the course of the night and
So you want his medical records?
I want to, first of all, subpoena him to get his witness, statement on record officially. And I would also like his records due to the nature of why they.
I'm not going to order. I mean, I'm not going to order medical records. If you tailor a request for something that isn't available in another fashion, then that's fine. But I'm going to deny that motion.
Yeah, a lot of my civil procedures, I will be correcting and will not have any more problems with. But as for right now,
your civil procedures,
I'm trying to follow the rules of federal civil procedures, and this is my
federal.
Yeah, this is.
Yeah,
I think so.
Okay, so we're a state court.
Okay,
and this is criminal proceedings.
Then thank you for your guidance.
Yeah, so you might want to start there.
Okay.
Okay.
So that 3 is denied.
Huh?
3 is denied, Your Honor.
The whole motion's denied, yes.
Thank you.
All 3 parts.
Mr. McGuff was seeking a court order to obtain private medical records of a third-party witness. In most state criminal cases, obtaining a third party's private medical information is extremely difficult due to privacy laws, such as HIPAA and legal privilege. The court is unlikely to order the prosecutor to execute a search warrant for such records. Mr. McGow explains that he is attempting to follow the federal rules of civil procedure, and Judge Simpson reminds him that he is in state court and that his case is a criminal matter. In the United States court system, there are two primary types of legal proceedings: civil and criminal. Criminal cases are initiated by the government against a person accused of breaking the law and may result in penalties such as fines, imprisonment, or probation. Civil cases concern disputes between individuals or entities, such as personal injury claims, and focus on resolving private conflicts or awarding financial compensation. The federal rules of civil procedure, which Mr. McGow referenced, govern the process for handling civil cases in federal courts. However, these rules do not apply to criminal proceedings or to cases brought in state courts, which are governed by their own procedural frameworks. In Michigan, criminal cases are regulated by the Michigan Court Rules, specifically Chapter 6, which outlines procedures for state criminal prosecutions. Since Mr. McGow's case involved a state-level felony charge rather than a federal civil matter, he was obligated to follow the Michigan Rules of Criminal Procedure, not the federal rules of civil procedure, which have no relevance to his situation. By using the wrong procedural playbook, Judge Simpson invalidated his motions.
Okay, so what are we going to do?
Well, I would like a chance to amend the motion.
No. You can file whatever motion you want, but I'm going to tell you something, sir. I'm not going to sit here listening to frivolous motions.
Okay.
I'm just not going to do it.
That's not my intent, Your Honor.
No, I don't care whether it's your intent or not. 3/4, if not 7/8 of that motion that we just dealt with was frivolous. It has no basis in law at all. You're just filing stuff. I'm going to tell you, I'm not putting up with that. Are we clear on that?
We are clear.
So what do you wish to do now? Do you wish to have a preliminary exam set?
Yeah, I'd ask for some for adjournment in order to review the discovery materials I've produced from my FOIA.
That what?
That I've came up with through my FOIA request. Or I'm going to plan on submitting the procedures as normal through the prosecution too, as well. But I need time to review the
What does
documents.
that mean?
That means I just got the documents and I haven't been able to review them, and I need time to review them. Your Honor. I can't decide on something and request for something right now in this moment if I haven't reviewed evidence.
So all you want is an adjournment?
After this response that I submitted to her and she submitted back, yes, sir, Your Honor. Adjournment for pretrial, adjournment for discovery materials.
You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that, Your Honor.
No, I don't think you do. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. This doesn't make any sense. I'll grant your adjournment. Next time you'll need to fill out a sheet to do it, but I'm not going to waste the time today to do it because.
Thank you, Your Honor.
And Your Honor, for the record, I put the email address the defendant should contact for discovery on this post-it note, which I'm going to place here, and he can pick up. He's indicated he doesn't want to communicate with me about his case.
He doesn't want?
Oh, at
He
that
doesn't want to
moment.
communicate with me about his case earlier, so I'm not going to speak with him today about this case. So I've given him the post-it note to get discovery.
Oh, yeah, that's a good way to get this going. All right.
At Mr. McGow's request, Judge Simpson postponed the probable cause conference until December 5th, 2024. Mr. McGow's case still remains pending. Both cases we showed here, featured in today's video, illustrates the problem of trying to mislead the judge with false information or the subjectivity of the facts when they have no legal basis. Although trying to cover the facts might look like the best way to get out of a bad situation, the truth and the facts may come to light and show the reality. Let us know in the comments which case or what kind of situation you would like to be analyzed. Thank you for watching, and don't forget to subscribe and share to help promote a more informed public.